Welcome to Off the Clock, a podcast by Procino-Wells and Woodland, where we take a team-centered, family-focused approach to serving the estate planning and elder law needs of our community in Delaware. I'm Megan Seksinski, Director of Community Relationships here at the firm, and I'm joined today by Katie Heald, one of our attorneys. Today we're discussing adult guardianships as an alternative to powers of attorney, so let's get started. Katie, we are jumping right in. Today's conversation is about legal authority and who gets to make decisions when someone can't. I'm hoping that our listeners take away two key messages. The first one would be having a diagnosis does not mean that a person has lost their chance to create an estate plan. And the second takeaway would be that when a person truly has lost the ability to put a plan in place, there is an alternative. So to start working on these takeaways, let's jump into powers of attorney. Can you tell our listeners what a power of attorney is and who needs one?
Sure. Thank you, Megan, for that wonderful introduction. Yeah, so a power of attorney is, a legal document, words on paper, that essentially says that in the event that I become incapacitated, I want to name this person, known as my agent, to step in and act for my benefit. The person who is making that power of attorney would be the principal. So the individual who is saying, okay, if I am not okay, I want this person, my agent, to step in. It's important to know that anyone that is 18 years or older needs a power of attorney. Delaware law says that once you are 18, you are considered a legal adult. So we consider this to be truly one of the most important estate planning documents for those reasons. And along with having it in place, it's really important to ensure that it is up to date, thorough, properly executed, so that it really does the job that you intend for it to do.
Mm-hmm. It is routine. It is at least weekly that we are sitting with clients and themselves or their loved one has some type of diagnosis that would affect their cognition. Examples would include dementia or Parkinson's. And so let's start by addressing whether or not a person with a diagnosis is disqualified from creating a power of attorney.
I'm going to give a big emphatic no. We assist families all the time with loved ones who have a early stage diagnosis, whether it's dementia, whether it's Alzheimer's. And so it's really important to know that a diagnosis does not limit their ability to sign these documents. Delaware law, the testamentary capacity is that you have to be of a sound and disposing mind and body, which boils down to, does the principal, the person signing this document, understand what they're doing at the time in which they're executing these documents? Do they understand that I am naming, Megan, for instance, to step in and advocate for me if I cannot for myself? So it is the time at which the document is executed. Earlier that day, there could be a point where maybe that person is not feeling like they would understand how to execute those documents. But then later in the day, you have a period of lucidity. So it's really important to understand that. And if this situation applies to you, if you have a loved one who is unfortunately diagnosed, to come in sooner than later and to call us, because it does not automatically mean that they are otherwise barred from executing these extremely important documents.
Mm-hmm. Such an important note. So let's go on to talk about the Delaware laws that affect this document and some of the signing formalities that are required to make this true and effective.
Yeah, so Delaware's power of attorney is controlled by the Durable Personal Powers of Attorney Act of 2010. It's a bit of a mouthful. And in that, it says that we can give our agent broad grants of general authority, and we can also give them more specific grants of authority. So, broad is what's referred to as general grants. So this is broad ability to access finances, maybe, manage property or legal matters. And then we switch to specific grants of authority, which are more specific actions that you permit your agent to be able to do on your behalf. It's really important to note, though, that the act, the 2010 act that I just referenced, explicitly says that if you do not explicitly list those specific grants of authority, the presumption is that your agent actually does not have that ability to do those certain things. So, this just kind of highlights the importance of sitting down with a licensed practitioner and kind of talking through what that means practically, the benefits and the risks of giving your agent that type of authority.
Mm-hmm.
In addition, Delaware's Power of attorney can include language that speaks to digital access to digital and fiduciary accounts. So allowing your agent to have the ability to access email accounts, bank accounts, things like that. So something that is definitely should be considered in adding into your power of attorney. Also, with the Power of Attorney Act, there is the ability to explicitly give your agent one type of authority over the other. So the two types that we can choose between, one being immediate and the other springing. Immediate says, I trust my agent. I want them to step in when they feel as though they need to. They do not need to receive a doctor's note that says that the principal is incapacitated. Whereas springing says, I only want my agent to step in when 2 licensed physicians have declared me incapacitated. So, all of these things that I'm mentioning, you can add into your power of attorney, or that should be otherwise included, is super important to be discussed with a licensed practitioner so that you can really hone in on, what do you want your document to do? What are you trying to allow it to accomplish? And what fits you best?
Mm-hmm. Really good information. Kind of like wish we could stand on the top of the community and kind of shout it with a megaphone. Really important things to know about the power of attorney. Other common questions in the office include, how can I name my agents? Can I name more than one? Can I name an order of agents? Can you speak to that quickly?
Yeah, it really goes to, the client's goals and priorities. So, there's so many ways that we can structure your power of attorney as far as agents go. The most simplest being one after the other. We have our number one person who we say they're the best person for the job. But in the event that they're unwilling or unable, then we prefer that this next person step in. If maybe one after the other is not your preference, we can name people together. And when we name people, AKA agents, together, we have to distinguish between what type of authority do we want them to have? Do we want them to, have a meeting of the minds, but otherwise they can physically act independently, or they can act independently? Or do we want them to be both required to be together at all times when conducting business on the principal's behalf? So, there's so many ways that it can be structured, and it just really comes down to, the people that you're naming, of course, and dynamics, and, who works well together, and who is best for the job. One of the things that I learned from, Michelle and Amber is it's always who's the best person for the job. We never want to choose those people based on, feelings. Unfortunately, sometimes maybe feelings might be hurt, but when it comes down to it, at the end of the day, you want the right person for the job.
Not necessarily the oldest child, not the one that
Right.
lives next door. So we have accomplished takeaway number one, saying if a person has a diagnosis, that does not necessarily prevent them from putting a plan in place that would include this very important document, the power of attorney. So thank you for checking that off our list. But of course, despite our best efforts, there are situations where a power of attorney simply is no longer possible, typically related to a lack of cognition. And when a person lacks that capacity to create a new one, the law does provide another path, and that's the adult guardianship process. So let's start, Katie, by talking about what is an adult guardianship.
Yeah, so I think in its simplest form, adult guardianship is a legal arrangement whereby one adult is granted the authority by the court to make decisions for another adult. And this decision has not come to lightly. It is come to based on the determination that that individual lacks the ability to make decisions for themselves, whether that be legal, financial, or whether that be medical decisions. But because this is, essentially the court saying that this individual is otherwise incapable of making those decisions, it is highly monitored by the court. And it is a bit of an arduous process to, be given that guardianship in the first place. So it's involved, far more so than a power of attorney would be. It is public, and it is a burden, but it is the next best, right? So that you can have those people that have your best interest being capable of making those decisions for you.
Mm-hmm. So let's get into the details and tell our listeners about who is who within the guardianship case.
Yeah, there's a lot of parties involved. So I'll start with the person with the alleged disability. And so this is the person that is incapable of making decisions for themselves. So when we first start off in the guardianship process, we call them the person with the alleged disability. And the reason why is because they haven't otherwise been declared to not have capacity yet. So it's the alleged disability. But they are essentially the person in question. Do they lack capacity and are they in need of a guardian? After the person with the alleged disability, you have the petitioner. And the petitioner is the person that files the petition, right? They're the person that says or that fills out the documents needed for the court and initiates this process. Another role is the proposed guardian. And so I want to make sure to distinguish between the petitioner and the proposed guardian. So the proposed guardian is the person who wants to become the guardian of the person with the alleged disability. Most times, the petitioner and the proposed guardian are the same person. So, they're petitioning the court so that they can be named as the guardian for this individual, but they need not be the same person. So an example of this would be an individual at a nursing home. And the nursing home is aware that this person needs assistance with managing legal financial decision making, but the nursing home themselves do not want to be the proposed guardian. So in that case, they'd be the petitioner, and then they would likely hire a third-party independent individual to be the proposed guardian if there wasn't a good family member otherwise. Then you have the attorney ad litem. And oftentimes, I liken the attorney ad litem to that of a background investigator. So they're appointed by the court first off, and their job is essentially to determine two things. The first is the person with the alleged disability truly incapable of managing their legal, financial, or medical decision making? And second, is the proposed guardian, the person that wants to step into this role to act for the person with the alleged disability, are they the right person for the job? So I call them that a background investigator, but they truly do represent the interest of the person with the alleged disability. Mm-hmm. So those are kind of the three, or I should say four, key parties that are at play in the guardianship process. Of course, you have the magistrate that is hearing over the case, but those are really the four core parties.
The main players. So earlier we talked about power of attorney. We know that's a legal document that lets our named agent, make legal and financial decisions for us. In the guardianship context, though, there's this terminology, guardian of the person versus guardian of the property. So let's kind of compare and contrast and explore what this means in a guardianship proceeding.
Yeah, I'm glad you asked because I didn't distinguish between the two. So it's very important to know that you can be the guardian of one's person and or their property. So it doesn't have to be both. It can be one over the other. So if you are named to be someone's guardian of their person, that means that you are managing their everyday medical decision making, personal life, more personalized decisions. So I liken that role to that of your agent in an advanced healthcare directive. We haven't talked about that today, but that is a medical decision making document. And so that's a very similar role. Whereas guardian of the person is your legal financial decision making, or sorry, guardian of the property is the legal financial decision-making guardian. So this is very similar to the power of attorney role like we've been talking about. So managing legal financial decision-making. To give an example of a case where maybe you'd have one over another. So I think about maybe someone who is 18 years or older that has a disability. So, 19-year-old boy with autism. Maybe he's capable of going to the doctor and relaying his medical preferences. But when it comes to the more advanced, managing of the finances, paying bills, he might not be capable of doing that. So in this case, mom or dad, in this case, or whomever, could become guardian of his property, but he's okay to not have a guardian of his person because he can still make those decisions for himself. So, it doesn't have to be both. It can be one or the other. It just really depends on the circumstances. And the differences between the two exist for a reason. We don't want to strip this individual of their ability to make medical decisions if they still can do so. And so the court, of course, accounts for that and their ability to pick between one or the other or both.
Okay, good to know. So, as we transition into the step by step process, we want to be transparent with our listeners that part of us exploring this in this setting is to emphasize, the burden was the word you used earlier, Katie, of the guardianship process, and be able to help families compare it to the ease of creating a power of attorney. Just further kind of stressing that the power of attorney is the better path, is the preferred path when the circumstances exist. All the more reason to emphasize planning while we are healthy and well and able to. But I say all that to set you up, Katie, to explain to our listeners what a person or a family would experience on a step by step basis to get through the guardianship process.
Yeah. So typically, when we have a client that walks through our doors and they have a loved one that is incapable of making decisions, and we have determined that there is no ability to sign a power of attorney, there is no moment in which we believe they would be otherwise capable of understanding the nature of that document, then that's when we turn to guardianship. And typically, we say that guardianship takes around 3 months. And so it takes 3 months because of the following. So, the first step in any guardianship case is to initiate the proceeding, aka let's file the petition. And so this is the start to it all. This is the petitioner in this case filling out the necessary documents, so the petition and a litany of ancillary documents, and filing them with the court. And they file them with the court, and it is basically saying, I am the petitioner and I am requesting that the court grant me the ability to make decisions on this individual's behalf. So that is the first step in every guardianship case, is just initiating the filing. But along with the petition is a document that's called the proposed preliminary order. And so this document gets us into step 2, because this document requests that, because this petition has been filed, that the court nominate an attorney ad litem and also schedules a hearing date. So once the petition and the documents are accepted, the court will issue that preliminary order, which does both of those things, nominates the attorney ad litem and sets the hearing date. So that's step 2, right? So once the court has issued that preliminary hearing, the attorney ad litem starts administering their role, right? So they begin their background investigation, if you will. They will meet with the person with the alleged disability, typically at their home or wherever they're comfortable. They will call the petitioner and the proposed guardian and interview them. And then they will also call all the interested parties that are mentioned in the document. They'll either call or meet up with them. And like I said briefly earlier, the goal of the role of the attorney ad litem is to discern, okay, does the person with the alleged disability truly need a guardian? And if so, is the proposed guardian the appropriate person? So, during this process, families can expect for the attorney ad litem to call interested parties that they may know and ask, are you okay with the proposed guardian being named? Do you have any reason to object to this? And, it can get to be kind of personal because of that. It's, a stranger, unfortunately, kind of inquiring into family dynamics and trying to really discern, is this the right person for the job? So that spans about a month. And then after the attorney ad litem has conducted that investigation, they create a report. And that report is then filed with the court 2 days before the scheduled hearing. And so that brings us to the next step, the hearing date. And at the hearing date, that is when the magistrate reviews all of the facts of the case. They read the attorney ad litem report and they discern, is this person in need of a guardian? And am I willing to appoint this proposed guardian based on all the information before me? So, assuming that the magistrate believes the proposed guardian is the fit individual for the job, they will appoint them. But unfortunately, that doesn't stop there. Um, the court is still involved. And, the court is involved because they are deeming this person to be incapacitated and are naming another individual as their guardian. So it's, the court wants to ensure that this is still appropriate, right? That we are still, this person is the right person for the job. And so when I say that, I mean that once they are granted that ability to act, they are then required to open up a guardianship bank account. So if this is a situation where the guardian is a guardian of the property, the court wants to make sure that the assets and finances of that disabled person are properly managed. So they're going to require an initial inventory that shows this is what the person with the disability first had. And then later on, they'll require a subsequent accounting to show this is how their money was spent. So there's, annual reporting requirements as far as finances go, but then also as far as capacity goes. So each year, the appointed guardian has to file an annual update and medical statement, which includes a doctor's note that says this person is still, otherwise incapable of managing their affairs. And so guardianship is still appropriate. So that's kind of the step-by-step how it works, but it's really important to know that once you are appointed the guardian of this person, it does not stop there. There are still ongoing obligations to the court because of the fact that it is a big deal, right? To otherwise strip this person of their ability to make, legal, financial, and possibly medical decisions for themselves. The court wants to make sure this is still appropriate.
Mm-hmm. Really good. Earlier in this episode, you used the example of a 19-year-old young man with autism and pursuing this process in order for him to have these people in place, guardians in place that can help him, whether it's your example, guardianship, helping with legal and financial matters, or also helping with medical decision making. I think sometimes in the community, what we find is that the perception is that guardianship naturally happens in examples like the one that you provided. But could we also quickly talk about real life examples that we've seen in the office where guardianship wasn't expected earlier in life, where approaching guardianship was something that the family could have never anticipated because of what led up to it? Can you talk kind of real life scenarios?
Yeah, I referenced a younger individual earlier, but I'm really glad that you are making, this point, Megan, because oftentimes, what we're talking about today is adult guardianship. And while that 19-year-old child with autism is considered a legal adult, oftentimes adult guardianship involves, married couples. Because there is this unfortunate assumption in the community that because I am married, I have the ability to make decisions for my spouse. And so it's a wonderful takeaway from this podcast is what should be just because you are married does not mean that you have the ability to make decisions for your spouse. So, a lot of the guardianship cases that we have is that unfortunate case where maybe your wife comes in and she has started to decline mentally, and to the point where now we are actually incapable of having her execute a power of attorney. The husband has waited too long, they've thought that everything was okay, and they've gotten to the point where she is fully incapable of executing those documents. So that is more of the, I'd say, common cases that we see. And it's because people just don't know. They don't know that they can't make these decisions until they can't, until they go to a respective institution or they call, the retirement account company to update something, or they want to maybe engage in advanced planning for their loved one. And they walk into our office and they say, want to engage in this type of planning. And we have to give them that unfortunate news that we can't do anything until after we acquire guardianship. So really important distinction to be made, Megan, and thank you for pointing that out.
So let's move on to some common questions and misconceptions. I bet we could answer these questions really quickly. One of which might be, can guardianship be contested?
Yeah. The whole reason why the hearing is held in the first place is to allow for those interested parties to object to the petition. So if we have a situation where, maybe I think about myself. I'm the oldest of 4 siblings, and maybe I don't have my documentation in place to nominate my husband to be my agent. So he files a document with the court. He does all the right things. He gives notice to interested parties. And then my sister pops up out of nowhere and shows up to the hearing because she's been given notice and says, I don't think that Nick is otherwise the proper person to step into this role. That would be a contested matter. And at that time, she would have the ability to present her case and to explain why she is the proper party and Nick is not. So yeah, they can certainly be contested, but this just kind of highlights the importance to having your power of attorney in place, because the most unfortunate part about guardianship is the person with the disability, with the alleged disability, is incapable of speaking to their preference most times. So we're not able to know what they would have otherwise chosen for themselves. And so that's one of the many reasons why it's so important to have your power of attorney in place, is so that you can avoid that family strife and name the people that you would prefer to be in that role when the time comes.
How about when guardianship ends? Does it ever end?
Yeah, it can end, and it would end upon a couple things. So, if that person with a disability regained capacity, maybe they were younger, they were maybe in some type of tragic accident, and they, for a limited time, were unable to make decisions, whether it was a coma or a litany of possibilities. If they were to regain capacity, then the guardianship would diminish. And that's also why the court requires that annual update and medical statement. They want to make sure that this person, that guardianship is still needed. Are they still unable to make decisions for themselves? Guardianship also would end upon, death. If that person passes away, of course, once you're no longer here, no one needs to make decisions for you. So, guardianship is not something that the second that it's in place, it is for good, permanent. It is a fluid, ongoing obligation that has to be routinely checked to ensure that it's still appropriate.
All right, last one, Katie. What do you wish that families knew earlier?
I wish that families knew that it is oftentimes not too late, and to not kick the can down the road and assume that they receive this diagnosis and it means that no longer can their loved one execute any document. I want them to know that it is so important to get the advice from a licensed practitioner, because they will be most likely surprised, and that we can probably still execute those documents. So my biggest takeaway, I would say, is to just call. It doesn't hurt to, confirm your suspicions. Maybe you're right, but you could also be wrong. And wouldn't we love for you to be wrong and for you to be able to execute those documents so that you can, act for your loved one's best interest when you need to. So don't wait, call.
I like that. Thank you, Katie. As we said earlier, if we could hope that you take away a couple things from today's conversation, it's that a diagnosis is not the end of your options, but the window can close. And once it does, the path forward looks a lot like what Katie helped us understand today about the guardianship process. So thank you, Katie, for being with us and providing all this good information.
Yeah, thank you, Megan.
Thanks for being with us today on Off the Clock. If you'd like to learn more about us, visit our website at pwwlaw.com. Of course, you can contact us directly by calling 302-628-4140 or emailing info@pwwlaw.com. We're here to help you plan today to protect your families tomorrow. See you next time. Anything discussed on Off the Clock is for general informational purposes only and is not intended to create an attorney-client relationship. To obtain the most reliable guidance, listeners are encouraged to seek personalized advice from qualified professionals.